Charles Rudolph is our next, and take a few minutes if you need to go to the restroom, refresh your coffee.
And don't be offended if I leave, I'd have to go make 4 cakes.
That's fine. That's fine. I won't make it.
Charles Rudolph is a partner with Plager, Croat, Bauer, Rudolph, and Stoddard in Freeport. He grew up in Pearl City, got his undergraduate degree at the University of Illinois, and graduated from NIU's Law School magna cum laude. And I believe, Charles, do you prefer to go by Charles? Do you get Chuck, or what's your preference?
I don't care much. And just
Thank
not
you.
Charlie. Paul a grudge ever since the kid threw a snowball with a rock. Charlie threw a snowball with a rock in it in my head.
I'll turn it over to you.
Thank you. So, just briefly to orient you to what is in the folders I'm passing out is the main thing is on the left. Your right is outline of. I'm excerpting from a larger presentation, so this outline has more material than I'll be covering today. There's something to refer back to if you have questions or can't remember the exact number I said on something. It may be in there. On the opposite side, there's a couple of folders that are, or letters I mean, that are expanding on some topics we'll be talking about today. And there's also this brochure with some more information about the firm. I've been with the firm for about 15 years now. My practice plurality has been estate planning and administration. Also just business, commercial transactions, tax, and real estate, and litigation related to those things. And my mother-in-law was a teacher in Mount Morris special ed up until the merger with Oregon, and she taught there for a couple of years before retiring. Claudia Distelbergen.
Sure.
So talking about estate planning, good starting point is, well, what's an estate? What's my estate? Broadly speaking, and I'll mention a couple different types or single purpose types of estates, a taxable estate or probate estate. But at its broadest sense, your estate is everything you have ownership or control over that if you become disabled or after you're dead, that needs to be transferred or managed. So your house, other real estate, the things in your house, bank accounts, savings, investments, retirement accounts, your private account with John, life insurance, all of that needs to be considered in your estate plan, because all of those things, something needs to be done with them. So I'm not going to spend much time today on why planning, because if you're coming out here for spend a whole morning on these topics, I think you're pretty motivated already. But I think just talking about some of the reasons can help frame the discussion to come. So the reasons to plan, I think, can be broken into 2 broad categories. The first one being control. Having control, it lets you have, by having a plan with proper legal documents, that is, lets you control who receives your property after your death, so that the people that you care for are provided for as best possible. It lets you decide who you trust to carry your wishes out. If you're not able to take care of yourself, it lets you decide who's going to manage your finances and your medical decisions. A second type of reason is to reduce the burden of your death or disability on your family. You can reduce or eliminate the need for court involvement at death or disability by having your wishes clearly stated in a binding legal format. It can often head off conflict between family members, and if you're, especially with medical issues, can be some very emotionally difficult decisions to make. Having your wishes clearly stated out as criteria for medical decision making, that can often reduce the emotional burden of having to make those decisions. It's probably still not going to be an easy thing, but maybe a little less. But before moving on to talk about different types of planning tools, I want to talk about probate because that's always looming in the background with these things. I think probate gets talked about a lot of the time like it's the boogeyman. It's absolutely horrible, absolutely must avoid, and there's going to be some definite reasons why it's preferable to avoid it, if nothing else, because planning that keeps your estate out of probate at your death saves a few $1,000s on administrative costs. But I take plenty of estates through probate. It goes smoothly when everyone involved wants it to go smoothly. So what is probate? Is a process for just after a person has passed to settle all of their debts and distribute their property. There's two tracks to it depending on whether you have a will or not. If there's a will, the first step is deciding whether that will is valid, and that's called admitting the will to probate when a judge decides that it is. If there's not a will, then the Illinois Probate Act says who your heirs are going to be. So one scare tactic I will engage in with this is that in your folder there's also a document called Last Will and Testament as prepared by the state of Illinois. We've taken the terms of probate and written them up as if they were a will. One thing that might jump out at you is if you're a married person, people normally want their property to go to their spouse to make sure they're taken care of and have the means to live comfortably for the rest of their life. What the Probate Act says, though, is only half of the estate goes to the spouse, the other half goes to the kids right away. In 15 plus years of practice, no one has ever asked me to write a will like that. Then the administrator of the estate is appointed. If there's a will, the will names who the executor is going to be, and the court will confirm that appointment if the person is willing to serve and is legally qualified, and the legal qualification amounts to just not having been convicted of a felony and being an adult. If there's not a will, then the Probate Act has a list of priorities for who gets to decide who the administrator is going to be. Either they serve themselves or they get to nominate and select someone else to do it. And one thing, if you don't have a will to waive this requirement, the administrator is required to provide what's called a bond and surety. That surety is basically pay a insurance company to act as a financial backstop. So if the administrator takes all the money and runs to Mexico, then the insurance company is on the hook to make the other beneficiaries whole. That typically costs over $1,000, even for the smallest estate anymore. So that's an added cost to maybe at least have a will, even if you to waive that cost. After those opening steps are done with deciding who gets the remaining property at the end and who's in charge, then there's the process for paying debts. You may have seen the classifieds claims notices saying that someone has passed away and that someone else has been appointed executor or administrator. And so if you think the deceased owes you money, send in your claim within 6 months or the claim expires. So that 6 months is a hard minimum for how long it takes an estate to go through probate. Typically there's a little bit of time after death before the estate gets open, a notice can be published, and then there's wrap-up time at the end. So 9 months to a year is a more realistic time frame for probate, and very often what actually drives the timeline is not that 6 month period, it is cleaning out and selling the house. So after the 6 months has passed, the assets are sold, rounded up, ready to distribute, then the net of the estate is distributed. There's a final report filed with the court. There is an accounting of all the starting assets and all the money in, all the money out during the administration of the estate. And if everyone's comfortable with what the person in charge did, they sign off to say we're happy with this, and the judge will just, okay, if everyone else is happy, I'm not going to argue. But if there's a dispute, then it ultimately ends up being decided by a judge. So with that Okay, so to summarize on probate, even if it goes smoothly as possible, everyone cooperates. There are reasons why you might still want to avoid it. Big one is saving money. You save the court fees, filing fees, $300. Newspaper publication costs a couple hundred, and surety on bond if there's not a will to waive it's $1,000 plus, and then there's the attorney's fees. So regardless of whether there's probate, there's probably going to be a lot of the same basic work to be done as far as file final income tax return, liquidate assets, pool everything together for distribution, or clean out, sell the house, other real estate, and that's all. So that's all going to need to be done either way. But avoiding probate means that you avoid paying on top of that whatever assistance that you might need from an attorney is the attorney having to write the court papers about that. So that's another several $1,000s savings. In some circumstances, by avoiding that 6-month claims waiting period, you can save time. And another reason that I think is going to be more important going forward is privacy. Probate files in court are public. A will gets filed saying at least who gets what shares of the estate, and an inventory gets filed saying what the property of the estate was. So anyone that's motivated to do so has been able to go to the courthouse and get access to that information. Court records are moving online more and more, and so going forward, I think that's going to be even more important. Just if anyone that wants to gawk can do that from home, just a few clicks on the computer. That's a much lower barrier of entry to looking into that. And if it's also at risk of just being gathered into all these online data brokers, adding to their profiles of you or your beneficiaries. And I think those things are already too invasive. So if privacy is important to you, that's another reason to keep your estate out of probate. So now with that background, I'll talk about some different planning tools. Some of these you probably have a good idea of what they are already, and I'll just be more raising concerns, things to look out for, and as much as how they're used. And these are also take a mix and match approach to these. It's not just like, well, my plan is gifts, or my plan is joint tenancy, or you would use some, if not all of these in most plans. So talking about gifts for estate planning, you know what giving is, but I want to emphasize that when you are giving property, you're giving it away. It's not yours. You lose control of it. So compared notes with some other lawyers, and one of the first cases in all of our property law textbooks in law school was a case where mother gives her house to his son, thinking, well, if I put his name on the title, then he's going to inherit it anyways, and then he doesn't have to do anything at my death to transfer it. Well, you probably see where this is going. They had a falling out, and he ended up evicting her. She contested in court saying, this was just a arrangement of convenience. It wasn't a real gift. He shouldn't be able to evict me. Judge had to say, no, you signed a deed giving him the property. Sorry, ma'am, but you're out of luck. She was evicted. So where gifts are appropriate as a part of an estate plan, it's either circumstances where you're worried about estate taxes and trying to reduce the size of your estate, or because you feel you can afford to be generous. Couple things to look out for is if you're worried about paying for nursing home care, if you make gifts in the 5 years before needing to apply for assistance, that can trigger a period of ineligibility. And if you are making gifts, there's some tax issues to look out for. So we have an illustration here of capital gains tax. I think what we have in mind is farmland's increased in value a huge amount over the last 30 years or so. The basic of capital gains tax is you're taxed on the difference between what you bought something for, that's your basis, or at least the starting point for calculating it. It can be adjusted. And the selling price. So you have a $40,000 piece of land you bought for $40,000 years ago. It's worth $640,000. You sell it now, you have a gain of $600,000. There's a few assumptions that go into calculating capital gains tax, but middle of the road set, about $170,000 of tax. So if you give that property to someone, the recipient, they keep your tax basis. So if they go to sell, if you try to give the farmland to the son so he can continue farming it, well, he has it at that $40,000 basis if he ever has to sell it. But what happens if you keep that property all the way through to your death? You get what's called a step-up in basis, where it's revalued based on the fair market value as of date of death. That's typically determined by an appraisal if it's not being sold to an unrelated party as a part of the administration. So you have a new basis of $640,000. It's sold, no gain, no tax. One thing is, if you are giving property and are looking to make charitable gifts during your lifetime, a good place to look is appreciated properties, and you give that to a not-for-profit like a church or other charity. They don't pay tax, so they can sell it and not pay the tax on it. So where gifts are appropriate for being made to individuals, though, it's best to give either cash or unappreciated assets. Next is beneficiary designations. So for some types of property, these are going to be the only way to transfer them. Retirement accounts, life insurance, those are going to pass by their beneficiary designations. What happens if you don't name a beneficiary, or the beneficiaries you've named pass before you? Typically, by the terms of the account or policy, they would go to your estate. So whatever you have in terms of a will or whatever the probate act says would govern them then. Thing to keep an eye out for is with beneficiary designation forms for these, where they may not be flexible enough to accommodate a more complex plan for distribution. If you said, well, I want to leave this to my spouse and then to my adult children, they typically work just fine there. But if you have different ideas for how to leave your beneficiaries, or have to something to diagram out on charts. Well, if this person, then this; if this person, then that. Or if there's issues with beneficiaries who are minors or disabled, you may not be able to accommodate everything you need to do. So in some circumstances, it's actually good to name a trust or estate as the beneficiary. Specifically with minor children, you name a 10-year-old as a beneficiary of a six-figure life insurance policy. Life insurance company's not going to write a six-figure check to a 10-year-old. What has to happen there is that a guardian has to be appointed to supervise those funds until they reach age 18. They have some authority to make distributions to or on behalf of the beneficiary for their best interest. But once they turn 18, whatever's left they get outright, which may or may not be a good idea depending on the amount and the responsibility of the person involved. Next tool is joint tenancy property. Probably having a good idea what this is, and if you're married, it's probably how you own your home and a significant part of your property. The basic idea is that you have a joint tenancy, and first joint tenant dies, property is now automatically goes to the surviving joint tenant or tenants. Real estate, there's not really anything that has to be done. Bank accounts, it's basically just a matter of take the death certificate to the bank to remove the deceased joint tenant. So where this can be really useful for estate planning is between married couples, particularly where it's a first marriage, long-term marriage, to keep estates out of probate at the death of the first spouse. So to illustrate this, and then extend it a little further to illustrate how things can go wrong, we have a hypothetical couple, Tom and Ann. They own everything jointly. So Tom dies. Ann's now the sole owner of the property, no probate, very, very minimal paperwork. But now Ann is the sole owner of the property, then that property is going to be subject to probate. So the joint tenancy only takes the couple so far, only to the death of the first spouse. Let's back up. Before Ann's death, She, a few years later, remarries. New husband, Dan. Remembers how smoothly everything went at the death of her first spouse. Decides, let's put everything in joint ownership again. Now, she is the first person to die in this couple. Now, Dan owns everything, including the house that the kids from the first marriage grew up in. But those kids, they are disinherited. It's all his property, no legal obligation, and stepdad has no obligations to let them have anything. Instead, he gets to distribute whatever property he inherited from Anne as he sees fit in his own plan. So issues that can come up with joint tenancy, as already mentioned, it only postpones probate. Moving property into joint tenancy, this overlaps with gifts, because if you make someone a joint tenant, you are giving them an ownership interest in the property proportional. What you can state a percentage, or it's if there's 3 joint tenants, then it's 1/3, 1/3, 1/3. So you've given them an ownership of the property, and so all the things I said about gifting applies to it as well. Then if you change your mind, you don't get to take it back. It only can be changed if the recipient agrees to do it. You're also placing it at any of the recipients' risks if they have debts, taxes, other legal problems, and those can all result in liens against the property. That's something that's puts it at risk of foreclosure or levy, and you may get paid out for your share of the property, but if it's your house, you're still out of it. And if you're worried about estate taxes, the first steps in estate tax planning for a married couple is to separate property to take advantage of both spouses' exemptions, with joint tenancy piling everything into the estate of the second to die spouse. It's not compatible with estate tax planning often. So, any questions so far? So the next planning tool is the will, and you probably already have the basic idea of what that is. You say where you want your property to go at your death, and who you trust to carry that out for you by naming your executor. If you have minor children, you can also nominate who you'd like to be their guardian. Wills go through probate, so if you have property that is not subject to joint beneficiary designations or a joint tenancy, that will be controlled by the will and go through probate, although there is a minimum threshold. If this total estate is less than $100,000 and doesn't include real estate, you can still bypass probate by using a small estate affidavit. They'll let you do more casual, informal, out-of-court administration for smaller estates. So wills, it's important to keep in mind, it doesn't control all property because joint tenancies and beneficiary designations supersede it. Regardless of what the will says, if you have a designated beneficiary on an account, it goes to that person. If you have a joint tenant, it goes to that person.
Charles?
Yes?
What would be the pros and cons of having an executor be a lawyer or a bank versus a family member?
Well, lawyers typically won't serve as the executor, but bank, financial institutions, trust department, a lot of local banks have one. I know Thrivent has that service as well. The pros and cons of that would be you are getting a experienced professional asset manager as the administrator. You are getting a neutral and objective third party. So if you're worried about if I put one kid in charge of the purse strings, that's gonna be a very uncomfortable position for them. The kids will fight. You don't want to name one over the other, but as the executor. But if you name them all, they're going to deadlock. So if you have some sort of circumstance where most of the time it makes sense just to name the kids. But if you don't have kids, or just don't think they're up for it, or don't want to put any of them through what you think is going to be involved, that would be something where you would go with an institutional trustee.
And they get paid for that service,
They do. Yeah, they're,
like a percent or something, or whatever is agreed upon.
yeah, typically they operate by a percentage, some possibility of where there's extraordinary services involved with complex assets, very needy beneficiaries, they have some add-ons at hourly rates, and there's a few banks that just operate strictly on an hourly schedule. So back to wills. Similar to what I mentioned with life insurance and beneficiary designations, you name a minor as the beneficiary. They're not, of course, not going to let the little guy here have a bunch of cash, so you have to have guardianship to avoid that, or the way of planning around that. And it's one of the topics in the full letters in the folder is use of contingent children's trust provision. It says, well, if a beneficiary is under, minimum needs to be 18 so that they're an adult, but ages 21 and 25 are very common ages, but you can specify whatever age you want. If a beneficiary is under that age, then I name someone as a trustee to hold the money in trust for them. We typically use a fairly broad standard of discretion for distributions to allow you name someone you trust to serve as trustee and let them use their best judgment about how the inheritance should be used to benefit your child, grandchild, whoever you're naming as a beneficiary. So they can cover appropriate amount for living expenses, pay medical bills if needed, health insurance, college tuition, sensible car at 16, etc. Until they reach the specified age. And one thing you can also do with beneficiary designations, if you have this sort of children's trust provision in a will, is you can point that designation, say, I named the children's trust created under my last will and testament dated whatever date as the beneficiary, and that can be a way to get property that wouldn't normally be controlled by a will into those, subject to those terms. Other thing to keep in mind for a will is that it only comes into play after death. It doesn't help for managing property if you become disabled. Sometimes people say, well, I'm named executor. But, yeah, that doesn't matter right now. They're still alive. Last planning tool is the living trust. I'm going to spend a little more time on this one compared to the other options because we think this one is the best way to avoid probate for most people, and as such has a lot of benefits. Basic idea with a trust, it can be characterized as a contract between me, myself, and I. When you're setting up a trust, there's three roles in the trust. You have a beneficiary of the trust that has the use and benefit of all the property that the trust ends up owning. There is the trustee of the trust that is the person who has management of the property, so they write the checks, invest the money, reinvest, buy, sell, they do all those things. And then there is the creator of the trust, sometimes called trustor or grantor or settlor. Those are all used interchangeably. I prefer grantor because that's the one the IRS uses. And as grantor, you would have the ability to amend or revoke the trust anytime you'd like. So what does that do for you then? Well, when you set up the trust, one of the goals is to transfer your property that would otherwise be going into probate into the trust. So now we have the Charles Rudolph Living Trust, which everyone agrees to say is a separate and distinct entity from Charles Rudolph, and that's the owner of the property that I transfer into the trust. So what happens if I become disabled? The trust is going to have a successor trustee designated, and the criteria and procedure for when they take over, typically based off of your doctor that's familiar with you and your health, certifying that you are incapacitated, not able to intelligently transact business. Then the successor trustee takes over. They are subject to what's called a fiduciary duty, meaning that they are legally obligated to act for your best interest and not use the position as trustee to benefit themselves. And the trust, this type is going to say, well, if I'm disabled, then the successor trustee uses the property to make sure I'm well cared for and comfortable as the assets of the trust will allow for. And so yeah, that is a way of keeping keeping your estate out of guardianship if you become during your lifetime. If the trust owns the property, then it doesn't need not subject to court supervision.
So do people use a family member for the successor or institution?
It's entirely up to the person creating the trust. Most of the time they do use family members, but the same reasons talked about you can have for a financial institution.
Is this similar to POA?
Yes. So even with a living trust that controls some of the property, I still recommend people do powers of attorney for property, because there's retirement accounts that won't go into the trust because of their tax status, life insurance, filing income taxes, dealing with Social Security. All those things none of those things are going to cause probate, but they're fine to not be managed by the trustee, but they are still things that need to be dealt with, and the trustee's not authorized to do that, so you still need the power of attorney for property.
I guess my question is, if there is already POA, is it also beneficial to have the trust in addition to that?
It really depends on just what. I guess I just wouldn't really consider having a POA a factor on whether or not to have a trust. You look at what your property is to decide, well, is there a benefit to avoiding probate after death, and that would be what drives the trust, having a trust, and not whether there's a POA or not.
Okay, so will and POA avoid probate?
Will does not avoid probate.
Well, and POA.
No. If you have a will and more than $100,000 or real estate, then your estate's going to go through probate after your death. What the POA does, that's two distinct sections. POA will help avoid a guardianship during a lifetime, which is a separate court procedure than the probate after death. So they apply to different time periods, basically.
So POA stops upon death?
Correct. With the limited exception for the healthcare power of attorney does authorize whoever's the healthcare agent to direct disposition or remains. But beyond that, no. And for financial, yes, definitely cuts off at death. So what happens at death with a living trust is that the successor trustee takes over, and the trust has instructions for how property gets distributed. Debts still have to be paid, but not with the publication. Just figure out who's owed money and pay them. And then the property is distributed as directed in the trust, and the living trust allows for much more flexibility than a will does as far as keeping property subject to some degree of control. You don't have to do immediate distributions the way that probate encourages. With probate, it's either distributed or the will has to establish its own trust. So with that flexibility, actually first just want to emphasize with living trust and mention that you transfer your property into the trust, which can sound kind of, is that a big deal? Charles Rudolph doesn't own his house anymore, the Charles Rudolph Trust does. So I want to emphasize that when you set up a living trust, you keep control of anything that you could do before you set up the trust. You'll be able to do afterwards. So buy, use, send, spend, sell, light on fire, anything you could do the day before you sign the trust, you'll be able to do the day after you sign the trust. And it also doesn't affect how you file your taxes. The trust does not have to file its own income tax return as long as you're alive. It lets you, the IRS doesn't care about it until after your death. You keep your accounts under your own Social Security number. The trust uses your Social Security number, and then it contains your instructions for when you're not able to call the shots directly. But with the living trust, it gives a platform for directing how property is distributed. very often people say, well, the kids are grown, they're responsible, they can just have their inheritances outright because I trust them. But there's often circumstances where that's maybe not appropriate. So things you can do with it, if you are worried about it not being spent prudently or spent down too fast, is you can provide for installments. You say something to the effect that, well, they get 1/3 of the inheritance immediately, or as soon as administratively practical after my death. 5 years later, they get the next third. 5 years later, they get the final third. So maybe they mess up the first time, but then hopefully they learn their lesson and you had a couple more bites at the apple.
Then who administers that?
Whoever you say. You get, if you have one kid you trust and
Have that be the
they have to be the trustee and holding everything, or that's where you would name a financial institution. You can also provide for income only from a trust, so you have to, common in second marriages, you say, well, I want my second spouse to be able to live in the house we've been living in, I want them to have income for the rest of their life, but I ultimately want the house and the assets that were largely accumulated during the first marriage, I want to make sure they go to the kids. So you can say that, well, you can write into a trust, so the spouse gets to stay there in the house as long as she like, and she can have income that all of my assets produce, and that the trustee at their discretion can pay from the principal assets of the trust based on criteria you put in the trust. Or that can work if you have say your child you don't trust financially and want to make sure that the money ultimately gets to the grandkids, is another circumstance where that can be appropriate. So that this sort of flexibility lets you deal with also lets you deal with if you have a disabled beneficiary where they are unable to work for whatever reason, reliant on means-tested benefits like supplemental security income or Medicaid. You can add what's called special needs trust provisions to preserve their eligibility for those benefits, but also then provide for some things that benefit their quality of life over and above what the benefits pay for. It's a platform for including the contingent children's trust provisions that I've talked about, and it also is a way if you have a beneficiary that you're worried about, well, they have debt trouble, they're vulnerable to financial exploitation. By putting the third party in control of the purse strings, you can have someone you trust doling out the funds in a way that's not subject to being exploited by a third party. So I've mentioned part of the process for setting up a trust and the way that it works. The way that's key for its functioning is that any property that would otherwise require your estate to go through probate needs to be transferred into your trust. So what as attorneys we're able to help with is real estate. Same time you sign the trust, we'll have you sign deeds transferring real estate to the trust. Have a bill of sale transferring personal property into the trust. But beyond that, if there's bank accounts, accounts at Thrivent, other investments, that is some homework that you'll have to do if you're setting up a trust, is go to those institutions. We'll give you a document called a certificate of trust that has the information that institution needs, and tell them I have a living trust, I would like to move my accounts to it, here's the certificate of trust, and they'll draw up the papers for you to sign to do that. A big exception to the rule here is retirement accounts. Because of their tax status, they cannot be transferred. If you try to transfer your IRA to the trust, it would trigger all the tax being due at once. If you're too young, a 10% penalty on property on top of that. So you don't do it, just rely on the beneficiary designations. And if you're worried about have a situation where you want to have minors as probably have minors as a beneficiary like I would, you can name the trust as a secondary beneficiary after your spouse, so that it then gets subject to the trust terms, in particular those children's trust terms. So I think I've talked about this now, responding to some questions. The option as a successor trustee is the financial institution, so I won't belabor that any further. So to summarize living trusts, the main reason to do a trust is to avoid probate. Other benefits can come up if you are disinheriting someone and you expect them to be unhappy about it. Part of probate is they're going to get notice that they're being disinherited and invited to challenge it. So if you're trying to disinherit someone, a living trust may be a better way to go. The trust administration is private, sometimes can be faster, and allows for more flexibility in keeping assets in trust longer if you feel that it's appropriate to exert some control over that property after you're gone. And if you're worried about estate taxes, it can be a good vehicle to avoid the taxes, because the first way to do estate planning, tax planning for a married couple is keeping property separate. So it provides a way of having you have a his and hers trust that benefits the surviving spouse. The spouse, the trust of the first to die spouse benefits the surviving spouse, and can allow taking advantage of both estate tax exemptions. So I guess I can end here or answer questions, or if you don't, I can.
I have a quick question for you, Charles. Would it be possible, you've given us an awful lot of information, would it be possible to get a copy of the PowerPoint? I can send an email to Heidi and ask if she can send me a copy. We'll give it to our office managers and distribute to this group.
So all the information that's in the PowerPoint is also in that outline that's in your folder, so.
That's prettier.
Fair enough. Thank you. Thank you, since I'm the one that designed it. Yeah, I don't think I have a problem with that.
I'll just send a note to Heidi then and ask her if, copy you on it, and ask her if she can get a copy back to us.
Yeah, I'll need to run it by the other partners.
Okay.
This is a lot, and that was a good recap, you know, that was a really good, hit the high points versus a lot of content, so, yeah, that'd be nice. Thank you.
Okay.
Any other questions?
Is there an expiration on POAs? I mean, how often? I ran into the situation with my aunt, she needed my POA, and yeah, they were maybe 4 or 5 years old, but when they really needed to be put in effect, somebody's like, well, you need to have her come in and sign a new one. I go, it's not happening.
That's not, that sounds like they were more would have been more motivated by, like, well, is this valid because it's old enough? We wonder if she signed a new one. And there's actually a new law that went into effect this year to deal with situations like that, because banks don't want to get in trouble for honoring an invalid POA. So there's now certifications that can be signed, and if someone says it's too old, it doesn't have to be signed by the principal of the power of attorney, but it comes up an agent. It basically says it's safe harbor for the bank to say, okay, yes, we will accept this older POA.
So that's something that's signed initially with the POA, the certification? I'm sorry, I guess I didn't follow.
It would be signed later.
Oh, by,
The agent will sign it, and they'll say, yes, we promise this is still valid, and if we're lying, we're on the hook.
and the agent is,
The person named to act on behalf
okay,
of them.
I gotcha.
And there's also another certification an attorney can sign and re-sign if the bank feels it's too stale. Yes?
All right, so all of my property and assets are placed into a living trust, and I designate how that can then be distributed once I die, correct?
Yes.
Okay, so that would be the most convenient, easiest place to put donations to charitable organizations.
Yeah, you can certainly write in, as a part of your distribution provisions, distribute property to distribute X dollars or X percent to charity. Other opportunities that come up if you have retirement accounts that you've not, pre-tax retirement accounts, it may make sense, well, I have enough outside of the retirement accounts, and whatever's left in my IRA, we'll give that to the charity because they won't pay taxes on it, rather than naming my kids and then saying, well, 50,000 from my trust, and that's all post-tax money.
Other questions? Thank you very, very much, Charlie.